Susan, I am showing that it's 9 o'clock, so I'm going to go ahead and get started.
Sounds great.
Okay, I just want to say good morning. For those of you that don't know, I'm Sherry Richards, the Director of Member Engagement here at SPAR. So thank you for joining us today. This is our Better Broker series on risk management. We have Susan Dioury with the Minnesota Realtors joining us. And this morning, Susan is going to be providing us with answers to frequently asked questions and hot topics from the Minnesota Realtors Legal Hotline. She will also cover upcoming 2022 changes to forms.
Yep, we'll go over that.
Susan is the Senior Vice President of Risk Management and Legal Counsel for the 20,000 plus member association of the Minnesota Association of Realtors. In this position, she serves as in-house counsel for the association and oversees operations of the risk management department, including the legal hotline, the Minnesota Association of Realtors approved forms, buyer-seller arbitration, legal defense fund, and the professional standards program. Susan has been with the Minnesota Association of Realtors since 1995 with a 4-year break from the association to finish her law degree. Susan is a licensed attorney in Minnesota, receiving her Juris Doctor from William Mitchell College of Law and her Bachelor of Arts degree from Augsburg College. Welcome, Susan, and thank you for joining us today.
Thank you very much, Sherry, for that very, very formal and nice introduction. So thank you all for joining us today. I am, as she mentioned, I do oversee the risk management area of at the Minnesota Realtors here. And of course, with that, we get to hear about everything that didn't go right in the transaction, unfortunately, or where you're having problems. Hopefully we won't ever see any of you at the professional standards side of things, but we certainly like to provide, our members with, information about what we're seeing going on in the marketplace. And of course, as we know, I know it's softening now, but we have been in an incredibly challenging market with a very low supply and a lot of demand for housing. So we're seeing a lot of unique things come about in this particular marketplace. And I just wanted to talk about 5 important points that we're seeing on the hotline. And then of course, as Sherry mentioned, I'll also cover the forms changes that are upcoming here just around the corner. But as far as on the hotline, we're hearing things about the financing contingency still, excuse me, the inspection area. We'll talk a little bit about the appraisal gap problem that we're still seeing on buyers in multiple offers, and something called a signing bonus. And I'll talk a little bit about that at the end there. So jumping right in, talking about the mortgage financing contingency section of our purchase agreement. I'm talking about the Minnesota Realtors residential purchase agreement. So the one you're using in the vast majority of your transactions. Just a reminder that we have 2 different contingency options in there. There's the first option, which is, right, you have all the way buyer, you tell me what financing you're going to go get, you're going to go get it, and you have all the way up to the closing date to get it. And then we're going to check the box on whether or not that earnest money is going to be refunded to you, the buyer, or if it's going to be retained by the seller as liquidated damages for their time, excuse me, for their time of holding up, waiting for you to see if you could get the financing. The second option is that written statement, right? And that written statement, of course, you're asking the buyer to provide that written statement. And if they don't provide it by a particular date, right, the seller has the right to cancel that. And currently, under the current language in the purchase agreement, the earnest money is automatically refunded to the buyer if it either doesn't close or seller doesn't cancel that before the closing date. So the important point about the written statement is this. First and foremost, we have to remind our buyers that they actually have a duty of good faith and fair dealing to try to go get it, right? So buyers can't be just saying, well, I changed my mind, I'm just going to withhold the written statement, or I'm not going to try to go get it. There's, in all contracts, we have an inherent in them the duty of good faith and fair dealing. And so that buyer cannot intentionally try to inhibit a seller from performing on the purchase agreement. So remember, we do have language in our purchase agreement that says, buyer, you will, in good faith, go try to get this funding and get this written statement. The whole point of this second paragraph in the written statement is because we know in our industry for, you know, it used to be that you used to sit down and qualify a buyer before you started working with them. But now we have a mortgage industry, lending industry that we rely on a great deal. And what was, of course, happening many, many years ago was we were getting all the way to the closing date, and seller had no clue whether or not this buyer was going to be able to get the financing or not, because we just didn't have any information regarding that. And so remember, the written statement is designed to provide the seller, it's an agreement between the parties that the buyer, you're going to provide the seller with information about your ability to close on this loan, to get this loan and close on it on the purchase agreement within this certain time period, preferably before closing, right? Because unfortunately, the seller is going to potentially suffer damages if they wait till the day of closing and we don't know whether or not this buyer is going to perform, and the buyer ends up not performing, right? I think the worst case scenario I ever heard was, you know, the $20,000 shipping to Hawaii of all the seller's stuff, and then the buyer just doesn't show up to closing, right? So, you know, the point of the written statement is to say, buyer is going to tell you, seller, where I'm at in getting this loan, and we're going to tell you that quite a bit of time prior to closing so that the seller can avoid any damages, right? Now, the important point about the written statement is that we are relying on an outside, you know, industry, so the lending industry, to help prepare this written statement. And it's important to note that we prescribe in our purchase agreement what the written statement is. It's not a pre-approval letter, right? It is not that. So that is not going to count as a written statement. We have to have a statement that's been prepared by the lender or originator. It has to be after the final acceptance date of the purchase agreement. It has to state that the buyer is approved for the loan specified in the purchase agreement. And it has to state that an appraisal has been completed that's satisfactory to the lender. And it has to tell us any conditions the lender is going to have for them to close on that particular loan. So what's of course happening is, here's my written statement, seller. And of course the seller says, well, this doesn't meet the obligations that you had in the purchase agreement, right? Your written statement doesn't have all of these things. And so therefore you haven't provided me the proper written statement by the time specified. And then what happens? Seller has the right to cancel. So those are some of the arguments that are happening. Of course, reason sellers wanting to do that, right, is because they've got the backup offer with a better price, et cetera, et cetera. So then we have, you know, these conflicting issues coming forth. So important to note that if you're choosing the second financing contingency option, make sure that you're getting that written statement timely, and it complies with the provisions that you have in the purchase agreement. Another phenomenon that's happening on the financing side is that, you know, again, buyers in their effort to try to make their offer appear more desirable to the seller, they are and you know, even though the buyer needs to get financing, so they've said it's 20% cash and 80% financing. For some reason, they're saying, I'm not going to check the financing contingency section of the purchase agreement, that it's not applicable. And you know, that's going to create a problem for a lot of reasons. You know, the whole financing contingency section, remember, is built on the purpose for all contingencies, right? A contingency is created in order for you to be able to excuse the buyer from performance on the purchase agreement, right? In this particular contingency. In other words, buyer can say, I couldn't get my financing, therefore I want to get out without penalty, or simply get out with penalty, like here's my earnest money, right? And if we're not checking that, we don't have all of the other provisions that we have currently in our financing contingency section, right? We don't have any obligation then for the buyer to go get that financing within 5 days or apply for it within 5 days of final acceptance. We don't even know what the seller doesn't know what the buyer is going to be even seeking. We don't have any opportunity for the buyer to you know, be able to be excused from performance from the purchase agreement. In addition to that, you know, in our financing contingency section, we have declaratory cancellation language, which means, right, if buyer doesn't provide me with that written statement, seller has the right to cancel. And if they do, it's automatically canceled. They agree to sign the cancellation of purchase agreement. They agree to do however they're doing with their earnest money, right? Return it to the buyer, generally speaking. If we don't have that financing contingency section, you don't have that declaratory cancellation from a seller side, right? So this is not beneficial to the seller to not have this contingency language in there either. If you don't have this contingency language, financing contingency language, the only option that the seller is going to have is to rely on your default language in your purchase agreement, right? And if you look at the default language in the purchase agreement, you can see seller has the right to cancel, sure, but it's not a declaratory cancellation. And so if there's a default, seller would have to, and buyer's refusing, for example, to sign that cancellation of purchase agreement, then seller's going to be stuck in a situation where they're going to probably have to either sue the buyer, excuse me, in district court, or more likely they want to cancel it and move along, and they'll have to initiate that statutory cancellation, which would provide the buyer a 30-day cure period. So in other words, as you can see, it's going to string out the seller's ability to get clear title back on their property so that they can go ahead and resell it to someone else. So although you might think that it appears to be something that might be more, that might be better because it's one less contingency, the reality is if the buyer needs financing, we really should be addressing all of these issues in our purchase agreement, so we know exactly what's going to happen and when, and whose interests will be protected or harmed. All right, the inspection contingency section. Just a reminder that in our purchase agreement, there are two options for inspections. I know another phenomenon we're seeing in this crazy, multi-offer on properties is I'm going to forego the inspection. And just a reminder that there's two options in our purchase agreement. First is you can agree that the buyer can get the inspection, but not make the purchase agreement contingent on it, right? Or you can say, I'm going to get an inspection and I need to make this purchase agreement contingent upon inspection. Again, contingency means we're going to allow the buyer to be excused from performance. They don't have to get to the closing table. They're going to be able to cancel the purchase agreement based upon the inspection. Again, another reminder, you have to do that within the inspection period, right? I do, as a buyer, have to, in good faith, go get the inspection. And I have to let you know by the end if I want to cancel, by the end of that inspection period, if I want to cancel. If I do not inform you in writing, if I do not inform the seller in writing that they want to cancel, then the purchase agreement is in full force and effect. And we are moving forward with the property and the condition it's in at the time they entered into the purchase agreement. So just a reminder, the seller is not obligated to renegotiate the terms of that based upon the inspection. They certainly can, but there's nothing that would obligate them to do that. So it's important to remind our buyers that if the seller for some reason is out of town, they're not getting back to you, the end of the inspection period is arriving, we need to make sure that we let them know, understand if they're going to proceed. If they don't want to send that written statement of cancellation, then they're going to be proceeding with the property and the condition it's in without the sellers changing anything, not purchase price or anything else. Another point I'll bring up is something that's come about called a walk and talk inspection. I know instead of trying to do an inspection contingency, they're trying to say, well, we're just at our preliminary review. We're going to bring an inspector along and we're going to do some sort of minimal kind of inspections. Just a reminder, under your duties under your code of ethics, you cannot allow anybody to access a property other than those that are authorized by the seller. So a showing should be a showing. And if you want an inspection, it should be an inspection, right? We should have permission from the seller to be doing an inspection if that is truly what we are intending to do. I know a lot of people ask me, well, what's the difference? Where's that line drawn? I think it's just one of those things you're gonna, just read your dictionary terms. There's clearly going to be a difference between a showing, right? A display, viewing the property, things of that nature, versus inspecting. We've received calls on the hotline and complaints where we have that walk and talk inspection, and all of a sudden we've got a drain pipe that's broken and roof shingles off the roof and things of that nature. And the reality is, if the seller hasn't authorized that, obviously that's going to create some problems for you. So just a reminder, if you're going to have that walk and talk inspection, just make sure that it's approved by the seller. It's just that simple. On appraisals, hopefully this is lessening now that we're kind of into this crazy market for a couple of years now. But obviously it's such a hard market. We're having prices bid up pretty quickly. And of course, those appraisals are always a little bit lagging behind. And so another kind of question that's come up is what happens if that the appraisal doesn't meet the purchase price? And there's been some very creative ways of trying to handle that. So the first reminder, of course, is that in general, we do not have in our purchase agreement a contingency specifically for appraisal. All right. So in other words, there's nothing in our purchase agreement that says you're excused from performance if the appraisal price doesn't match the purchase price. So in other words, if you're in a cash deal and you say, I think your house is worth $500,000 and here's my offer, and you accept the offer at $500,000, and I, as a cash buyer, decide to go get my own appraisal, and I find out that they say it's only $450,000, too bad for me. $500,000. I thought it was worth $500,000, so therefore I'm bound to purchase at $500,000. I think where the confusion comes in is in our financing contingency section, right? So if we have a financing contingency and the buyer wants to be excused from performance, unless they can get that, financing, of course, that's where the question comes in about is if I say I want 20% down for cash and 80% I got to get financing, and I have a financing contingency, obviously I need the lender to agree to give me the 80% of the purchase price, right? And if the lender says, well, there's not an appraisal that's satisfactory to me, and therefore I'm going to decline the loan for 80%, right? Then that's a financing contingency issue, and a buyer could be excused from performance on the purchase agreement based upon the financing contingency language because they couldn't get the financing for the 80%, right? So that is different than an appraisal contingency. And of course, the other component here that you need to keep in mind is for FHA and DVA loans. As you know, there's a federal law that says we cannot require a buyer, we cannot penalize a buyer essentially, and they have the ability to get out of a purchase agreement if it doesn't appraise based upon FHA or DVA's interpretation of the appraisal. So we have to be able to let them out. Again, from a financing perspective, we have to be able to let them out without penalty on an FHA or DVA. So the only other reminder here is that I know many people are trying to draft these, what they're calling, appraisal clauses, or, trying to draft language that would require the buyer to come up with a difference. So if I have I have to go get a loan, right? And let's just use the $450,000 to $500,000 example. If we're going to try to force that buyer to come up with the extra $50,000, right? In order to close on the loan, and we want to draft that in such a way in the purchase agreement that, in other words, requires the buyer to come up with that money. So we have an appraisal gap clause, in other words. If you're going to do that, my only recommendation, of course, is, make sure that you're drafting it, think through all of the details if you're going to be drafting that particular language, right? Obviously, I'm certain that your buyer doesn't have an unlimited amount of funds. And so obviously there's got to be a, what are they willing to go up to? Because we're not going to know the answer to what the gap is until after we get the enter into the purchase agreement and get the appraisal done. So important to, have conversations with your buyer of what's the limit here? We're going to draft in that limit, and answer all of the other questions, right? Is this going to be paid at the closing? Is this additional earnest money? What are all the details? What happens if it's what happens if it's above and beyond that? Who has the right to cancel? What happens to the earnest money? In other words, just do your due diligence on making sure you're drafting the language so that all of those questions are answered if you're going to be requiring the buyer to come up with those funds. And of course, depending on who you're representing, the more detail you may need. All right. Buyers on making, I shouldn't even call it multiple offers. It's more like multiple acceptances of offers. Another phenomenon we're seeing in the marketplace is buyers who are entering into purchase agreements for more than one property with the intention that they're going to cancel. For example, if you enter into 3 purchase agreement, they intend to cancel 2. So they're only going to purchase 1 property. And that of course creates lots of problems, ethically, legally. Again, as we talked about earlier, we have the duty of good faith and fair dealing. That's inherent in all contracts. And that's just your contract law basic, right? We have the duty of good faith and fair dealing. When 2 people make a deal, they're supposed to be doing what they said they were going to do, right? Obviously, for you as realtors, your obligation to your client is definitely primary. But of course, you have to treat all parties honestly. We cannot be deceiving other sellers into believing that you're going to be a buyer's going to be performing on a purchase agreement when they fully intend to cancel. Another thing you need to think about is your obligations under your licensing statute about disclosure of non-performance. I'm not sure exactly when you think that in this particular circumstance. I'm not sure exactly, where you're going to draw the line in saying that there's a non-performance of a party here. If you're walking into all 3 purchase agreements knowing that they intend to cancel 2 and never perform on them, certainly creates a legal and ethical dilemma for all of you as realtors as well. So again, remember, when you're representing your buyers, you do obviously, when you're representing them, you have fiduciary duties to them. You have the fiduciary duty of obedience, but remember that ends where it's not a lawful instruction, right? And so if your client is asking you to do something unlawful, we obviously do not have to comply with that unlawful instruction and should not be complying with that unlawful instruction. So very, very important to help your buyers understand that I know that they're struggling to get the property they want. But we do need to really, unless they're really intending to purchase all 3 properties, right? And then they choose to get out for a particular reason. We have to remind them we have to act in good faith and fair dealing. We can't inhibit that seller from, tying up their property. That's the other point here is, this is a very serious issue. When we enter into a purchase agreement, this is not like other contracts. In real property, when we enter into a purchase agreement, the seller is giving the buyer a legal equitable interest in their property. So the buyer has a legal right in their property once we enter into a purchase agreement. And there are consequences, there are all kinds of ramifications to that. And so it's really important for buyers to understand that this is not just I'm in today and out tomorrow. We are actually literally tying up somebody's property and affecting their ability to resell it, et cetera. All right. The last thing I want to I wanted to talk to you about is this something called a signing bonus that we're hearing about. And the signing bonus, again, I don't know a lot of details. I have more questions than I have answers, really. But I wanted to just sort of get it in front of everybody to see if we can make sure we curtail some of this. But essentially, the market is so tight that we are having some people who are saying, apparently, what I'm being told on the hotline is here's $10,000 in cash from the buyer. The buyer is giving it directly to the seller, and they're calling it a signing bonus. And of course, big red flags for all kinds of reasons, right? First and foremost, boy, oh boy, is this in your buyer's best interest? How is this related to the purchase agreement? How are you accounting for this to them? Is there a federally backed mortgage loan involved? And if so, does the lender know about this? Otherwise, we got potentially for mortgage fraud here. And again, if this is supposed to be part of their earnest money, right? Or earnest money that's just, intended to be non-refundable, period, that should be written up in the purchase agreement. We should not be having just literally some cash under the table from the buyer to the seller without going through the brokerage, there's obviously some significant legal and ethical issues here. So from a brokerage standpoint, particularly, again, you know your obligations under your trust account requirements under Minnesota Statutes 82. Any funds received by the broker through the broker obviously have to be going through your trust account. So it's important to have this conversation with your clients. Let's keep everything on the up and up. Again, certainly you can call it a signing bonus or a non-refundable earnest money, but make sure that we're diligently following protocols from the standpoint of addressing that appropriately in the purchase agreement and moving it through the proper channels if it's going to be part of a purchase of a sale of real property. All right, so those are my hotline tips. And now I'm just going to try to see if I can't give you an overview of the forms changes that are coming out. Just to give you all a sense of what we do every year at the Minnesota Realtors. We have a forms committee that meets. It's somewhere usually between 20 to 30 members who serve on that committee. And we collect suggested changes from our members all year long. And if you're interested, you can always go to our website. There's a suggested change link on there, and you can submit your suggested changes there. We also, of course, continually monitor and review if there's any precedential legal cases that we need to be aware of. And of course, we have our own lobbying team here at the Minnesota Realtors. And of course, they always are present at the Capitol all year or during session and, keeping track of regulatory changes as well as legislative changes. And so all of those combined are what we monitor every year. And then we change our forms every year, once a year. And I know you're all are going to throw your rotten tomatoes at me now because it always comes out on August 1. And I know people hate that. It's in the midst of your selling season. But the reason we do that, there is actually a rationale is because at the legislature, when there is a legislative change, the legislature's new statutes always become effective August 1. And so that's their default. And so we have always just stayed with the legislative default so that if there is a legislative change, we're not doing it more than once per year. So that's why it's August 1. I know it's painful for you when you're in the midst of selling season. It's hard to learn it and hard to adjust all your forms at this time. So we try to do our best to, be thoughtful about our forms changes and try to do what we feel is pertinent for any particular year. And if we tried, of course, to make sure we collect several suggested changes in order to change any particular form. So what's happening this year on the residential side, on the addendum or amendment to purchase agreement buyer's move-in agreement, you'll notice that we modified some language pertaining to the insurance section. Specifically, we used to have language in there about the buyer requirement to obtain $300,000 of liability insurance and naming the seller as an additional insured. And what we were hearing from members in the market is that that's not even possible to get, apparently, from insurance carriers. And so you'll notice that we modified that paragraph, and the new language simply states that the buyer shall purchase and maintain liability insurance effective on the possession date, and it requires the buyer to provide the seller with an insurance binder. And of course, reminding them, buyer, that they're responsible for their own personal property insurance. So, again, even though we have a purchase agreement, buyers moving in early, we don't have a closing date yet. We haven't transferred title. So remember, sellers still liable for, they're liable for that structure. And so, of course, they're wanting the buyer to be able to get some protections themselves if they're going to be living there as far as that liability insurance is concerned. So we did modify that. The second one is real simple. It's a addendum to purchase agreement, the SSTS and well water inspection contingency. We literally just changed the title. And I know you're like, you just said you only change important things, but this issue keeps coming back to our forms committee about expanding this particular contingency to be particularly for the well, to be beyond the testing of the water. And our forms committee just keeps having this, has had this debate several times, and they do not want to expand this contingency to be part of a mechanical inspection of the well, right? So if you want a mechanical inspection of the well, the intent is that you get a inspection of the property. What we're talking about with this is just the well water inspection, right? So we want to make sure that the water is potable. And so that is what this contingency is intended to be limited to. And so that's why we've decided this year, maybe if we just change the title, people will be very crystal clear. This is not intended to be a mechanical inspection of an inspection of the mechanics of the well itself. All right. On the buyer representation and facilitator services agreements, you'll note that by last year we had removed some language that had the checkbox option that in the section pertaining to the authorization from the buyer to the broker that allows the broker to seek compensation from the seller or the listing broker, right? There's a paragraph in there that the buyer's authorizing the buyer's broker to do that. And if they do that, right, you're required to provide them with a disclosure before they enter into a purchase agreement as to what that cooperating compensation would be. And we used to have language in the actual rep contracts themselves that said, this amount shall or shall not reduce buyer's obligation to pay the broker, right? And we removed that last year, and by popular demand, we had a great deal of requests to bring it back. So even though you're using the compensation disclosure to buyer form that says, here's your new disclosure, here's your new compensation obligations, there was just this desire to have that language back in the buyer rep contracts and facilitator services agreements to make it crystal clear to the buyer that if you do seek cooperating compensation and you do obtain cooperating compensation from the seller or the listing broker, that it shall or shall not reduce that obligation. So we added that language back into the buyer rep contracts. So people felt a little more comfortable just having that clear in the contract up front and early. The other thing we clarified, just real simple for those of you who are working on the border there, maybe many of you might be in the St. Paul area, might have Wisconsin licenses. There was a question that arose as to whether or not our representation contracts would apply to properties if they entered into a representation contract, for example, with a broker who was both licensed in Minnesota and Wisconsin, and they ended up purchasing a property in Wisconsin, whether or not this representation contract would cover that. And so we clarified that this contract is only intended for representation for properties located in Minnesota. So again, obviously, I would hope our members understand that there are different requirements in Wisconsin, different forms required in Wisconsin, different disclosure obligations, et cetera. In Minnesota, your buyer representation contract is quite prescribed by statute. You have to have substantial compliance with it by law in order for you to even seek compensation from a buyer if they failed to pay. So obviously these representation contracts usually are quite regulated and specific. But in any case, we wanted to clarify it's just for properties located in Minnesota. On our disclosure statements, we made a couple of modifications there. In the general information section, you're going to see that we modified language pertaining to the homeowners association. There's been quite a bit of confusion about if a property is subject to Minnesota statutes 515B, which is the Minnesota Common Interest Ownership Act. And so when they aren't subject to that, we wouldn't be using that addendum, the CIC addendum, but we still want to know, right? From a buyer perspective, we still want to know, and the seller should be disclosing that there might be an association, even if it's not going to be subject to 515B. And so we just kind of brought out that information a little bit clearer in its own line as whether or not there's an association or if there's any shared amenities. So you'll see that new question on it, that question on a new line in the disclosure. We also modified the insurance section. We have questions about whether or not there's been a homeowner's insurance claim, and we revised that, eliminating the reference to homeowners. There was a circumstance where there was coverage that was actually by an auto insurance coverage because the automobile ran over the yard and damaged the real property itself. And so it was actually the auto insurance coverage, not the property insurance coverage. So we wanted to broaden that question so that would be any claim related to the property from any insurance. So you'll see that there. And then we also just modified the appliances section. We changed invisible fence to in-ground pet containment system to be consistent with the language we have in our purchase agreement. In the purchase agreements themselves, we actually only had a couple of changes. They are in, two of them are in the financing contingency section. And this is probably the most important one I want to stress today. And that is the section where we're modifying the section pertaining to the written statement. Remember, we just talked about a few minutes ago about what the whole point of the written statement is, and the fact that we are relying on an outside industry, the lending and mortgage industry, right, to be able to provide that written statement. Well, important note here is that in that written statement section where we say that if the buyer doesn't provide the written statement by that time period, the seller has the right to cancel. And if they don't cancel before the closing date and we don't provide the written statement, then we have language in that contingency section that says the purchase agreement is automatically canceled. In both sections, as I mentioned to you earlier, the current language defaults the earnest money to be refunded to the buyer. What you're going to see in this new change is that you're going to have a check option, and it's either going to be retained by the seller or refunded to the buyer for that earnest money. So very, very, very important that if we have a purchase agreement where we've checked that earnest money is going to be retained by the seller, if the buyer doesn't provide a written statement, you're going to have to be very aware of this, right? From the standpoint of your buyers, being able to be very diligent about your buyers following up with those lenders to make sure they're getting them the written statement and making sure we're providing the written statement in time. Otherwise, the consequence is the buyer's going to lose their earnest money for failing to provide that written statement. Again, I think this was from the forms committee perspective, there's just a great deal of frustration about buyers not acting in good faith, right? And not going to make an effort to get that that written statement and really just holding up the buyer, or, excuse me, holding up the seller, and causing them some damages from keeping their property off the market, et cetera. So very, very important to note, just be very diligent about looking at that section to make sure, again, I'm going to suspect that in most cases, buyers are going to offer in their offers, it's going to be checked as them getting their earnest money refunded, but that doesn't mean that the seller isn't going to counter, particularly in this market, to ask for the earnest money to be retained by the seller in that circumstance. So certainly going to be a negotiating area for you, and certainly need to be paying attention to the time period if it is going to be retained by the seller, and having the buyer understand that is most important. Another important change we made to the mortgage financing contingency section is a removal of the language pertaining to whether or not the buyer had to get a if they needed a contingency for the down payment assistance, bond, or grant program. We had a question in there pertaining to that, and we did end up removing that. And we had received some many requests to remove that particular language. There was some concern by some members that there was just misunderstandings about the buyer's ability to complete a transaction if they were going to obtain that kind of financing, and they felt that it was just putting their buyers at a disadvantage by having the contingency language in there. And apparently in most cases, when we're getting those down payment assistance or grants or bond programs, most of the time it's usually approved prior to them even making offers. And so there was argument that this particular contingency language wasn't necessary because it usually is correlated with the loan type that they're getting, which we have a financing contingency for anyway. And so those were some of the reasons that the forms committee decided to remove that. If there are programs, down payment assistance programs that will require sellers input, we obviously still have the seller's contribution to closing costs section that you can address that issue there as well. So then there's just one other change in the purchase agreement. You'll note it you'll see in our notices section that we added language pertaining to discriminatory or restrictive covenants. I know SPAR has been very instrumental in the just deeds and those getting that corrected. And so this is actually just a notice in our purchase agreement that allows buyers and sellers to, or mainly sellers, to know that discriminatory or restrictive covenants are obviously illegal and unenforceable. And that the property owner themselves can get it removed from their title by just reaching out to the county where the property is located. So they have the ability to do that. And then real quickly, I know I'm running short on time here. I know this is very brief overview of the changes, but we did add a couple of new residential forms for those of you who are working on estates or some more and more properties. It seems to be that there's more than 2 sellers or 2 buyers. And so we added a new addendum to purchase agreement, additional signatures that just allows you to facilitate additional signatures other than 2, beyond 2. And then we also added a new addendum or amendment to your representation contracts and facilitator services agreements. And that's an interpreter appointment. So for brokers who have clients where, for example, English is not their primary language, or they might need sign language assistance, this new form will allow your client, your buyer client or seller client, to appoint an interpreter of their choice, and essentially just gives your brokerage permission to be able to provide confidential information through this interpreter, and that interpreter can relay that to your client. And then, of course, just clarifying that, it's the interpreter's obligation to, interpret that correctly, or, translate that correctly to your client. So, and then on the commercial side of the forms, that's all we have for residential. See, it wasn't too bad, wasn't too painful. But on the commercial side, it was very similar to what we did on the residential side. The only difference there is on the counteroffer addendum, we actually added some language clarifying, like we did in the residential side last year, just clarifying that we got to have that counteroffer and all of the other pages of the purchase agreement signed and delivered before we have a final deal there. So that's just some language we clarified in the counteroffer addendum. And then the other representation contracts, we added that language back in. And in the purchase agreements, we added the discriminatory restrictive covenant language in the notices section there as well. So see, you can handle it, I think, hopefully, from the standpoint of the forms changes. It wasn't too bad this year. We tried to, like I said, be very, very thoughtful about what we actually changed, and kind of get down to the critical components until we have more pressing issues. So, and those will roll out August 1. If you're a broker and you need help in getting your logo on and things of that nature, you can certainly reach out to Lone Wolf, and they're there to assist you in doing that as well. So otherwise, I'll stand for any questions, Sherry, and if there's any questions, I'd be happy to answer them. Otherwise, that's all I have for today.
Susan, thank you so much. And if anybody has questions, we have a small enough group. If you want to unmute yourself and just go ahead and ask questions, you can. I also threw something in the chat, and last time I looked, I didn't see any questions there. So
I'm very thorough.
You are very thorough. I love it.
No, it's no problem. I'm happy to answer any questions, even if they think of them later.
Right.
I have a question.
Yeah. Hi,
It's
Patty.
Patty Jo. So Susan, when we're talking about the financing contingency, if it's a cash transaction, we're still, I mean, we're checking cash. So do any of those things apply for a cash transaction, or are we just?
Nope. So you're right. In a Patty Jo, in a cash transaction, you would not be checking that the financing contingency is applicable, right? But the important note there is that there is no appraisal contingency, right? So again, our forms committee has debated this issue long and hard for many years. If a buyer walks in and they say, I think it's worth $500,000, and here's I want to pay $500,000, you know, why do we care if an appraisal thinks it's $450,000? If you're a cash buyer, you're going to be paying $500,000, right? We do not have any contingency that would excuse that buyer if it didn't appraise for $500,000, in other words. So yes, you're right. In a cash deal, there is no financing contingency that would allow the buyer to be able to be excused if the lender decided they weren't going to give you that much for the loan.
Thank you.
Yep. All right. Anything else? No, I've stunned you with too much information. No, that's all right. Sherry, thank you again for inviting me to speak, and you guys all know where to reach me. So if you think of any questions later on, you know where to find me.
Thank you so much, Susan. I appreciate it.
No problem at all. Thanks so much. Have a great day, everyone.
All right. Bye-bye.
Bye.